Hello and welcome to IP in a Post-Brexit World, brought to you by the Chartered Institute of Patent Attorneys, live from our head offices in London, which is of course in England, in the United Kingdom, and still at the moment in the European Union. This is brought to you through the support of the government's Brexit Readiness Fund, and also in conjunction with our media partners, Worktime TV. We are live through the internet across the world, broadcasting to regional hubs in the UK, in Glasgow, in Manchester, in Cambridge, in Hatfield, and also we have a special hub set up in Munich for our members there. We know that we've had huge interest, not just from around Europe, but across the world in this. We've seen questions already through the online Slido app from countries Italy, France, Germany, Spain, and we're expecting to see far more come through as we go through the programme. We were sat, not in these offices, but in our last offices 3.5 years ago, the morning after the night before, that was the UK's referendum on its membership of the European Union. And for the last 3.5 years, and you'll hear more of this as we go through the broadcast, CIPA's worked quite tirelessly to ensure that the UK leaves the European Union without the IP system being damaged too much by any unintended consequences. Our international work for the last 3 years has been heavily focused on Brexit. We've been very much stressing that as far as patents are concerned, it's business as usual, but that there will be some changes, and particularly that those changes will impact on the world of trademarks and designs. Our council members have been probably the most active in our work on Brexit, and I'm delighted to be joined today by 3 council members, by Julia Florence, who is CIPA's president, by Alicia Instone, who is the incoming vice president. Alicia takes office on the 1st of January and also leads on CIPA's work on designs and copyright and is influential in trademarks. And also Matt Dixon, who is the focus of CIPA's work around business practice and what it means for firms. The event is being brought to you via the Slido app, and so for Slido you will need to go to slido.com, and we encourage you to do that. Once you've logged in there, you just need to simply enter the event code, which is #CIPA, and there you will be able to click on the question and answers tab, type in your questions, enter your name, and please tell us where you're from as well, because we're very interested to know how far we're reaching with this event, and then click send. We will also be using the polling function in Slido. So go to the polls tab, you just type in your answer text, you go to voting as and select your name, and then click send. So we're going to try a little warm-up poll, both for the audience in this room and the audience around the world on the web. We're very interested to know where you travelled from today, or where you're watching from today. And as you tell us where you are, you'll see the cloud tag, the word cloud, grow. And it's interesting for us to know exactly how far we're reaching with this broadcast. That's quite impressive already. London looks like it's the largest area for participants, and that probably is no surprise. And obviously our regional hubs are featuring heavily there. But I'm seeing Poland, Spain, exotic locations such as Slough, Jersey and Hull. I think that's proved to us that the polling function works, and that's important because we're going to return to the poll towards the end of this broadcast with some important questions for you to bring us some feedback. So without further ado, I'm going to ask each of our panel members to talk to us for a few minutes about their areas of interest and their areas of work on Brexit. And the first of those is going to be Alicia. So Alicia, tell us something about your experiences in the worlds of trademarks and designs.
It's been interesting because there's been lots of being thrown in at the deep end, which is quite good. So we've had lots of meetings with the UK government, in particular with the UKPO, also with DEFRA and with the MOJ. We have quarterly meetings with the Marks and Designs Forum, known as the MDF, not the Medium Density Fibre Board, and we have those quarterly and they keep us updated there. But we've also been brought into separate meetings to talk about rights of representation, about the transitions of the rights onto the UK register, special meetings that went on for hours about seniority claims, just to make sure that the UK IPO put the legislation correctly in place for the creation of what are going to be called comparable or re-registered rights. In doing this, we've also been brought in very confidentially in meetings to actually go through the SIs that were being laid before they were laid, to spot if we saw any errors. So I got brought in to have a look at the Trademarks SI, and because they were doing it when I was away on holiday, they actually had a separate meeting for me to go in and speak to them separately, because they wanted to engage everybody on the process to make sure that nobody was missed. So that they rearranged the things specially. On the design side, Dave Musk has been heavily involved on making sure those ones were scrutinised, so that nothing went through, without us having a look at it. Although we didn't have too much influence, they were receptive if we spotted any sort of nuances. All the way through, the UK IPO has been very, very engaged with the procedure with us, which has been good. We've had also meetings with DEFRA, where they've informed us about the GIs process and what's happening there, and we've heavily pointed out to the MOJ and everybody at every opportunity we could about the issues surrounding the rights of representation. We will continue working with the government on the rights of representation issue. Again, whenever I see them, I bring it up as a, by the way, you do realise this, and we had a meeting where they got berated quite heavily recently, which was quite fun. But they are aware of it, and they're going to be continuing to look at it.
So no one's trained you for this, and I think this is an interesting aspect of when people find themselves working as volunteers in professional bodies. How have you found being parachuted into this world of sort of lobbying and campaigning on behalf of members and also the users of the IP system?
Yeah, it's nothing I've ever come across before. It was quite daunting to be held up as being the one who is looking at these and scrutinising these and checking the documents. It's quite a responsibility. It's also nice to be trusted in that responsibility and to feedback something. It's been quite fun on that respect, but also quite daunting as well.
And what do you think has been the most challenging aspect of the changing world for designs and trademarks?
Challenging aspect. We've been having to make sure the UK IPO didn't do anything strange, or too strange, to make sure that it didn't inadvertently give anything away in terms of the rights, which is where we've been focusing. So anything that they could do, we've been making sure that they didn't do anything too strange in their implementations, to make sure that it was as smooth as possible for users, for business, because they had looked at various models to start off with, and we worked with them, telling them the pros and the cons of each of the models, and looking for issues that might be there. So, yeah.
Thanks, Alicia, and a big thanks on behalf of our members and also users of the IP system for all the work that you've done. So moving to you now, Julia, in terms of CIPA's work, patents and everything related to patents, but also the work that we've been doing nationally and internationally. Do you want to share some of your experiences and thoughts with us?
Yes, thanks, Lee. It's been obviously very interesting. A lot of what we've been doing on patents mirrors what Alicia's been doing on trademarks and designs. Certainly for patents, for European patents, we're in the very fortunate position that Brexit does not actually affect European patent work for the UK. But we know that there's been a lot of misinformation and misunderstanding, particularly outside of the UK, as to how that could be the case. And so for 3 years, even before I was in the role, Stephen and Tony and people from our International Liaison Committee have travelled all around the world, giving our message that for patents, for European patents, Brexit has no effect and it's business as usual. And my mantra has also been that the Europe that we're trying to leave is quite distinct from the Europe that grants our patents. So I think that's been a good message, and I think it is being well received now around the world. People, I think, are beginning to understand that the EPO is not an EU agency, it's an international organisation, and the EPC is not EU law, it's an international agreement, and that's why Brexit has no effect on the EPC. But we have had to take that message far and wide, and we continue to do that. Certainly, again, in terms of working with the UK IPO, I have to say they have been fantastic in making sure that we're kept up to date with issues that are arising through Brexit. One part of the patent space that is partially affected by Brexit is the SPC area, because of course that is governed by an EU regulation. And we know that all EU regulations that are in force at EU exit day will become retained EU law. So we will have the same effective legislation in UK after Brexit. But there has been a need to fix certain parts of the legislation which, for example, refer to other EU agencies and EU legislation, and those need to be amended so that they refer instead to UK bodies and to UK legislation, so that the law will operate smoothly once we've left the EU. And as Alicia said, that's been done by means of statutory instruments, SIs, and again, CIPA's been very heavily involved with the SIs relating to SPC regulations.
I know you've travelled extensively to represent CIPA in your year so far as president. How have you been received in terms of the business as usual message and the way you've been working on behalf of members when you're overseas?
Yes, I think we've been very well received. I think everybody's been very interested to hear that message, and there've obviously been lots of questions, but I think people are glad that we've gone out to demystify and clarify as far as we can what's happening with IP and Brexit.
And what would you say have been the biggest or most important questions you've been asked when you've been on your travels?
Oh gosh, certainly there have been a lot of questions about using the EPO and whether UK attorneys will be able to continue to represent clients, which of course we will be able to. Yeah. So we've had a lot of questions about that. We do get a lot of questions about the UPC, and of course at the moment the UPC is being held up by the German constitutional challenge. But the UK did ratify the UPC agreement, and in fact CIPA Stephen Jones, when he was president, wrote to Theresa May urging that the government should ratify, and so it was very pleasing they did. But we obviously have to wait and see what the outcome of the German challenge is before we can go further with that. But I know that the UK government's stated aim is to continue to negotiate with Europe to ensure that the UK can play a part in the UPC after Brexit.
Thank you. Finally, Matt, your work's been very much around business practice, and you yourself are a business leader in the IP space. So do you want to give us some of your views on how businesses are potentially affected by a Brexit of any flavour, really?
Well, I think that's part of the challenge, I think, on advising on these general kinds of business issues, is we have very few definite answers on these kind of more general things. And although we work hard to demonstrate to the government and those in leadership that we are an important aspect of the UK economy, we tend to come fairly low down in that list with our special needs. Special needs might not be the right term, but there are special aspects to business. We're quite an international industry. And what that means, of course, is that issues come up about, well, how am I going to continue to run this Anglo-European organisation? Those kinds of issues come up, and they become difficult to answer because post-Brexit, part of that becomes an issue for national law, which we don't necessarily know about yet. So the issues around the continuing rights of employees, both EU nationals in the UK and our UK nationals that are working in, for example, in Munich. I'm sure plenty of our members there are also UK nationals, and those residency requirements. And in terms of the current agreements or non-agreements that we have, how that will continue, those are very much things that are on our members' minds, but are difficult to provide definitive answers of the kind that a patent attorney likes across those subjects. There's also, when you consult around the government advice, so having been through the Brexit advice, on the subjects of what the IP laws are going to look like going forward, and the government's obviously very interested to get our view because we provide expertise. In the other direction, it can look a bit more scant, and that provides difficulty for our members on some of these specific issues. We do have a trump card, of course, because as Julie has mentioned, then the EPC is an international agreement, it's independent of the EU, and our European patent attorneys have the right to establish a place of business in Germany and The Hague, where the EPO is. And I think that's a very useful and reassuring thing for our members at this time, to know that that is there, and our understanding is that that's already automatically part of German law.
So the reason for the government making this money available for organisations like CIPA to do events such as this was because they were concerned that businesses perhaps weren't as ready for particularly a no-deal Brexit as they might wish them to be. Has it kept you awake at night? Do you and your colleagues running your firm and those that you know running other firms, has this been sort of a major player in terms of business strategy?
I think overall, like all businesses in the UK and actually in Europe, it's just that level of uncertainty, and business does not like uncertainty, and it makes it very difficult to plan for the future, and also increases the level of risk on business decisions to be able to say, well, we just don't know what it's going to look like, or perhaps even we don't know what it's going to feel like. And so it makes it harder to make those kinds of decisions. And, well, as I said before, particularly in a patent attorney community, then that kind of level of risk and uncertainty is particularly unpleasant, I think.
And in terms of that uncertainty,
yes,
what's the biggest risk for the UK profession? How could that play out in terms of our relationships internationally?
The biggest risk for us potentially is that we are seen as somehow sidelined, and I think that's something that businesses really need to think about, is how actually to turn what looks like a threat into an opportunity. It's classic business strategy, and to say, actually what we have is we have the advantages of being within the EPC, important from a patent perspective, but we are not within the EU, and that gives us greater flexibility.
So that's turning a potential sort of tumble over a cliff into something that looks slightly more positive, maybe.
Yeah, it's a challenge to turn a tumble over a cliff into something that looks positive, but maybe you sprout wings, and that could make it work.
Thanks, Matt. Thank you. Okay, so we know that we've got folk in the UK watching, in Italy, Spain, Germany, Finland, Poland, Canada, and in the States. So it really is a global audience that we have. What we're going to do first, though, is to give you folk here in the CIPA Hall the opportunity to ask any questions of the panel you might have. Please wait until a microphone comes your way, not because we need to hear you, but because, of course, those who are listening around the world would very much like to hear your questions, and then to hear my panel's responses to those. So if you just let me know if you've got a question, I'll get a microphone to you. One at the front, please, Catherine.
I'm Vicky Salmon. I'm a member of CIPA Council. I'm just going to ask Alicia if she would kindly run through what's going to happen on the trademark front in terms of what's happening to registered rights and unregistered rights. so that we can just make sure that we know that we're all on the same page and we understand where we are with our representation rights. And just to run that on a recap, if that would be okay.
Thanks, Vicky. So a very straightforward question about what's happening in the world of trademarks, Alicia.
Yes. So, any EU trademarks that are registered at 11 o'clock whenever we leave.
Thursday? No, it's not Thursday.
Not Thursday morning. So whenever we leave, I say 11 o'clock because you were an hour ahead, will have a comparable trademark created on the UK register. So the UK will basically pick it up and move it all over. It will have the same ending number prefixed, and I'm going to get this wrong, 009, I think it is for the, let me just double check this one, give you the right numbers. Because there's a 009 for one and 008 for the other ones. If I give you the wrong one, I'll get told off.
I'm sure no one's going to tell you off, and I'm sure people are easily able to go and look the numbers up.
Yes, okay, so yeah. 009 for EU trademarks, and then the rest of the trademark number. They will have the same effective date, same priority date, same seniority date, same goods and services, same everything. They'll just be a complete clone of the right. And from that date onwards, it will exist as if it were a UK right. So you would have to challenge it under the UK. It will have citation letters generated against it as current standard UK marks are at the moment, and it will go through. If you have a pending trademark, it's not quite registered on the day, you will have 9 months from exit date to refile in the UK, claiming effectively priority from your European filing. If you have a European designation on a Madrid application, and the statement of grant of protection has issued, you will have a comparable trademark IR generated at the UK IPO with a starting number 008 on exit day, and again it will carry forward as normal. WIPO have indicated that should you wish to have this as a designation under the Madrid, there is a system of surrender and putting it under the Madrid if you want it there rather than as a separate national, because otherwise it's going to be created quite separately. And that's the trademark. So basically, if you have anything registered, you will have it automatically created. Anything that's still pending, whether it's an IR or whether it's a national European, you will have 9 months to reapply. Designs?
Yeah, why not?
So in relation to designs, same basically. So anything that is registered and published on exit day, any EU community designs that are registered and published on exit day will have a comparable, so it's going to be called a re-registered design created on exit day. Again, exactly the same information, same details. The number will be starting with a 9, then the full digits of the registered community design without the dash hyphen in the place, and they will all be created. And if you have any pending designs, or if you have any designs that have been allowed but where you've deferred publication, these will not have a re-registered design created, and you will have to file again with a 9-month priority period window for one in the UK. As with the Madrid, the same with the Hague designs. So if you have any Hague designs where the EU has been designated, and the statement of grant of protection has issued on the EU designation, a re-registered IR design will be created before the UK IPO, and if it's not yet registered, you will then have the same procedure. If you've requested deferred publication before the EU IPO, you can also request deferred publication for the new 9-month priority claim and design for a maximum of 12 months up to the period of time you have left remaining on your registered community design.
I mean, that was really authoritative, and that's because you eat, live and breathe this. This, of course, is the filling in the sandwich for attorneys, and there was a lot of detail there. Presumably, CIPA and also our sister organisation, Chartered Institute of Trademark Attorneys, have got comprehensive guidance online.
Yes, we have our Brexit practice points, where I've tried to, on the trademark and design side, lay out what's going to be happening and what you need to do as an attorney in your business. So checking the registers, how to maybe you want to create records. That's why I was concerned with the numbers, so I took the right ones. Making sure that you had everything in place, thinking about security interests, if you need to record licenses, that kind of thing. So everything's there as the Brexit practice points, so things you should be checking through as a checklist for your businesses.
Fabulous, thank you. So, so that's the sort of level of information you're going to get back if you ask a question. Do we have another question here at CIPA? There's one at the back.
Hi, my name's Mark Saunders. My question relates to the principle of exhaustion. And could you give a steer? I understand the UK government is going to provide a temporary period. What will happen during that and after that period, and whether it'll be reciprocated by the European Union or member states relating to goods placed on the market with the European Economic Area, whether they will be exhausted post-Brexit?
Exhaustion. Who wants to take the question on exhaustion?
Yes, I'll
Yeah.
deal with that if I can.
Yeah, please.
See if I can get the words in the right order. Exhaustion is obviously fairly complicated. So at the moment, the system of exhaustion within the EU means that if you place a good on the market in the EU, those rights become exhausted throughout the area. So after Brexit, what will happen? The UK will effectively be a third country as regards the remaining EU 27 states. And what the government has said is that for goods that are placed on the EU 27 market, they will continue to regard those rights as exhausted vis-à-vis the UK, so that parallel import of goods can continue from EU into the UK. However, we are not aware that there will be a reciprocal arrangement. So goods that are placed on the market first in the UK will not necessarily be exhausted vis-à-vis the EU 27 states. So it may be that if you place your good on the market in the UK, you will still have to check whether there are relevant rights in the EU that would prevent you importing those goods from the UK into the EU.
Thanks, Julia. And I think, again, important to say that, that CIPA has published in its briefing notes online information about exhaustion, and it's a resource for people to use.
Indeed. And of course, the whole issue of exhaustion is very difficult. I know the government has been consulting on it, but of course, different sectors want different things from exhaustion. I think we'll just have to see what is the outcome of those consultations. And obviously, CIPA will be making representations whenever it has an opportunity.
Thanks, Julia. We're going to cut across now to an online question that we have. It's from David Jackson. And David's asking if his business can continue to rely on pan-EU IP rights, such as European trademarks and registered community designs, for protection in the UK after Brexit. So, Alicia, do you want to take that one?
Yeah, so if David has any registered rights on Brexit, there will be a UK comparable trademark or re-registered design created. So he would then be able to rely on those for enforcement in the UK, provided he then kept them in force, pay the renewal fees as required. If, however, going forward post-Brexit, he wanted protection in the UK, a UK filing, a UK trademark or UK design filing would be required if there wasn't one already in place. You couldn't post-Brexit file a pan-European registered community design or European trademark and expect it then to have an effect in the UK. Okay. A separate one would be required.
Yeah.
But beforehand, if you had one, a new one would be created, but going forward, new rights would be required.
So in David's case, if I've understood that, he's not relying on that EU right going forward, he's relying on the fact that that's been mirrored in the UK.
Mirrored in the UK, yeah. So you would rely on the mirrored UK right going forwards for UK protection, not the European right. So if you were only interested in UK protection, you could in effect let the European part of it lapse. if you were only protected interest in the UK, but going forward a separate UK right would be required.
Fabulous. Thank you. I will take another online question. It's from Glenn Davis. And he says he's got a number of registered community designs. Sorry, all of these are coming your way. At the EU IPO. And will these transfer to the UK IPO? Is there a cost? And what happens to his EU rights? So
on Brexit Day, whenever that is, automatically, free of charge, no cost, the UK IPO are going to be creating the comparable trademark for the EU registered trademarks and the re-registered design for the registered community designs. No input is required. These are happening automatically. They are doing them for free, no charge. So these will all be there. In terms of the existing EU rights, that will remain there as well. It's just after Brexit, you will have two rights and you will have to maintain and pay renewal fees for the two rights independently. They will become completely separate, not related to each other at all.
And presumably you could allow your prior EU right to lapse at renewal?
You could, yes. You could choose to let it lapse. And if you didn't want the UK right, you could choose to let that lapse if for a reason people didn't want it. Or even if for whatever reason you didn't want your UK right at all, for example, if you had a license agreement or other coexistence agreement that said, I'm not having a UK right, I agree not to, you can opt out. But the opting out process isn't available until Brexit.
Until we've left, until we've left, whenever that might be. James Wilson says he's got both patents and trademarks in the EU. I think this is a political question more than it is a technical one for us, but James says, how can it be right that patents continue unaffected and trademarks are revoked? That might not be accurate, of course. It's madness. It's madness, I tell you. Who wants to take that? Matt, do you want to, I mean, I know you've come to talk about business, but you might have a view on the madness of...
Well, it's a simple point of harmonisation, isn't it?
Yeah.
It's a straightforward point of harmonisation. That's just the way it is. The EU has achieved some harmonisation across trademarks and designs, got very close to some harmonisation across patents, and yeah, that's the way it goes. I think it's good news for us from that point of view, because we're able to progress this message of business as usual on the patent front.
Yeah.
Because obviously, as we said in the beginning, the EPO is not an EU agency,
Absolutely.
and EPC is not an EU legislation. So we're clear on the patent front, which is good.
Whereas the EU IPO is, and James's question suggests that trademarks are going to be revoked. Alicia, that's not the case, is it?
No rights have been revoked. The UK government has made it very, very clear that no rights in trademarks or designs will be lost. In terms of the UK bit was breaking away, a comparable trademark or a re-registered design will be being created, and the remaining EU trademark or registered community design will stay for the remaining 27 countries as a separate entity, and you can renew it, license it separately from the UK right, and it will stay there for as long as you pay the renewal fees.
Thank you. Shall I come back to the room? As you've had lots of opportunity in the room here at CIPA to think of questions. Has anyone got a question for us where we conjure up some more online questions? There's one at the front.
Hi, Kevin Bader from CIPA, your sister organisation, who's been doing a lot of work around Brexit as well. I just wanted to ask the panel whether they thought there was any risk of any increase in sharp practice or scam activities as a result of Brexit.
Oh, so those nasty scammers. We've all, even CIPA receives letters from scammers, so they clearly don't bother to do their research first. So does Brexit give an opportunity to these sharp practices?
I think I would say that anything that's confusing or has uncertainty in it gives that opportunity. On those kinds of sharp practices that I've seen, the thing that always impresses me is how much people are prepared to pay in response to a scam compared to what they would have to pay in response to perhaps a normal service. So I think there is an opportunity. I'm certainly not advocating that as a business opportunity for anybody.
Very important that you say that, Matt. I think I know you've been involved in some conversations at the EU IPO around these scam type activities, haven't you?
Yeah, so CNIPA, the Committee of National Institutes of Intellectual Property,
The pan-European organisation for people like us.
Yes. they sit on the anti-fraud task force, and we've been working with those as have CIPMA. So CIPMA first reported to the EU IPO the practice of a particular firm who were suggesting that one ought to re-register their European trademarks on Brexit. Because at this point the UK IPO hadn't clarified 100% that they were going to be creating these comparable rights, and they then got a telling off, which was quite nice. And they're still doing their renewal scams, but you know, one thing at a time. They set up to make themselves look like a proper law firm, so a different tack to the usual. Yes, I think it's just a case of people being vigilant. If anybody spots anything, let people know, because we can feed it into the organisations, because the Anti-Fraud Task Force at the EU IPO, which we're members of and will continue to remain members of, because our pan-European is pan-European, not pan-EU. So we will continue to have a voice on those bodies where you have Europol sitting, INTA sit as an observer, the USPTO sit as an observer, because they're having similar issues in their offices as well. So if you spot anything that looks a bit iffy, or any of your clients do, just, you know, or anybody spots anything, just make sure you say, hello, have you seen this one before? Because the more evidence they can get, the more chance they have of curbing and quashing these things before they get too far along.
And I think we would encourage CIPA members and CIPMA members to feed those back through their respective organisations, and then we can do that reporting for them. So so it's simple, really.
Yes, tell us or CIPMA, and we will feed it through to the right people who need to know about it. But just let us know, because we don't always see all of these. Occasionally we'll see our own if we've got the, you know, if somebody's filed our dodgy mark or doing it. But they come in cycles. So if our mark isn't up for a renewal or something at that time, you don't always spot it. So be vigilant out there, people.
Thank you. I'm going to return to some online questions, but I'm also going to just remind my audience in the room, I will come back to you. So please think of questions, and you can always surreptitiously get the microphone to you by indicating to the back of the room, and then we can come to you when we're ready. So a couple of questions from Graham Cotwell, who says, do I need to appoint an attorney in another EU country as a representative for my EU trademarks? And also, if his trademark is challenged somewhere in the EU, would he have to appoint a local, that's a non-UK attorney, to represent him?
So, many firms in the UK already have or are in the process of setting up their own firms in mainland EU, shall we call it, and or reciprocal arrangements with other firms who are able to act and able to continue to act post-Brexit and meet the various requirements. So depending on who your rights you're already with, I mean, if you hold the rights yourself and you don't meet any of the requirements, then yes, you might need to appoint somebody, but you don't necessarily need to look outside the UK for appointing people. Your UK attorneys will most likely have arrangements in hand where they can assist. In terms of the mark being challenged, it depends when and where and how it's being challenged. So if it's being challenged before the EU IPO, the same representatives who act for you before the EPO can assist with that. If, however, it's unlikely to be challenged in the court separately unless you've decided to bring an action in the courts. So usually you go back to the registration body to challenge they shouldn't have this trademark, and it would usually only be challenged in the courts. Again, it would depend on which countries allowed what as their jurisdictions, but it would usually come back to the EU IPO. So the same people who could assist in the representation would be able to assist in the challenges as the first point of call.
So I think what I'm hearing there is, don't worry.
Yeah, we've got it in hand.
Your attorneys have got this in hand. They've been thinking about this for a long time now.
Yes. And if you don't have your own attorney, first port of call is ask your UK local attorneys to assist.
Thanks, Alicia. So we're going to move away from trademarks now, which I'm sure will make you feel that you can take a short, well-earned rest. I think, Matt, it's coming your way because it's business stuff. So what implications are there for UK firms with offices in Munich, or I guess offices anywhere actually in the EU, but Munich's going to be a biggie for us, isn't it? Can UK firms continue to operate in Munich under UK corporate structures?
Okay, so that's two questions. One's the implications.
Yeah.
So there will obviously be the implications of if you've got UK nationals working in there, you need to establish a residency for them. But the bigger question tends to be around how do you continue to have a business presence there.
Yeah.
So as I said before, we've got a right under Article 134 of the EPC
Yeah.
to establish a place of business, and our understanding is that that is automatically enacted into German
Yeah.
law. So we're not aware of any implementing legislation, but it's automatically there as a right. The question of how that is practically carried out post-Brexit will be one for German national law at the time, and we will continue as CIPA to maintain lines of communication with the UK government to facilitate that, but also carefully with the German authorities to make sure that our members can continue to operate as they have before. In terms of the business structures and the corporate structures, then with the change in EU law, our understanding is that some of the mechanisms, for example, a UK LLP or an English LLP won't continue to be
Yeah.
a mechanism
Yeah.
that can be used in the same kind of way. And part of that is to do with the recognition of UK attorneys as acceptable partners for German attorneys, and so it will be a case of investigating other mechanisms for business structures.
And presumably that's something that firms need to be thinking about now, because we know that this change is coming.
I think that those firms with those structures are aware. The question is, what do you move to following that? But of course, there are mechanisms for international, at least profit-sharing arrangements across jurisdictions that are both in the EU, outside the EU, these kind of Swiss Verein or other kind of options. So those may be the backstop position.
Yeah, a backstop. That's
No,
what we need.
different backstop.
We need an IP backstop.
Yeah.
You said right at the start of that, it's a very, very short statement, that it's important for firms to ensure residency in Germany. Is that relatively straightforward, or is that something that people need to do some work on?
I think the question there is not one that I have detail on. However, it's the same situation that it is for any business.
Presumably there'll be some sort of sense applied to all of this, won't there? And things aren't going to change overnight. People aren't going to be kicked out.
No, exactly.
Yeah.
I believe that Germany has said there is going to be a grace period.
About 3 months, I think we've
I
heard.
think that's the information that we had, but it will be a case of looking into the local law for where your people are located.
Cheers, Matt. An anonymous one, and it touches on Article 134 of the EPC. So that article provides a right for an EPA to establish a place of business in Germany. Does it automatically provide that right of residence?
So I don't know whether it doesn't say it's automatically enacted into German laws. It doesn't say that. What I don't understand is how you could have a place of business in Germany without some ability to be resident in the country to do that. Whether that goes beyond, whether that's residency that goes beyond your right as an EPA to have a place of business. In other words, if you stop being an EPA, whether you'd have continued residency. But then I don't think that's the overall question. So I think I cannot expect that when we need to invoke that, because we've never had to do that before. And when we need to invoke that, I can't see that there will be a challenge to your ability to be resident if you've got the right to have a place of business.
And we've been saving this one up for you, and it's had to come at some point. So Stephanie James asks, UK attorneys will retain their right to represent clients in EPO hearings, as you've said, but getting there is a different matter. Will we need a visa?
We don't know. We don't know. Our expectation in discussion with others, and there are varying views that we have heard, but our expectation, I think, is that this will be viewed as a business meeting, is the same as any other kind of business travel to go to represent a hearing, in which case we would expect certainly light touch immigration provisions. And that's also something that we've talked about dealing with the immigration authorities, either potentially directly in Munich or with the German embassy, to say, actually, how do we facilitate this most easily?
Yeah, we had a conversation about this last week, and we touched on the fact that the crux of this is around whether it's working for gain or not, because that's the bit that takes you out of the 90 days and 180 days flexibility that we would otherwise have if it was a business meeting. And I think the jury's out on that. In terms of we've had different advice about whether that is working for gain or not working for gain. It seems like it's going to be just seen as a business meeting, but I think you said to me last week, this isn't going to be top of the list of priorities for people who are standing on the border.
That is correct. But we continue as so. I think the different views that we've had have been from other, for example, professional bodies for other kinds of professional advisors.
Yes.
And we of course have, at least as European patent attorneys, we have that trump card in our back pocket, which is that we have a right to establish a place of business.
It's a game changer for us, isn't it? If no one else.
I think that's right, and it gives us a different story to consult on compared to other professional advisors that are looking to say, well, can we operate in this jurisdiction? For example, just as classic lawyers.
Yeah. Oh, Julia, yeah, please.
I just was thinking can I add something to that?
Yeah.
I mean, one difference that we have with, say, lawyers is that we don't need to worry about mutual recognition of qualifications because our European attorney qualification is the same across Europe.
Yeah.
Every EPA sits the same exams and gets the same qualification. So that perhaps gives us an advantage there. And also, I think the EPO is incredibly supportive. They want to see us continue to be able to travel to the EPO, represent before the EPO, and we are, as we are engaged with the UK IPO, we also have very good discussions with the EPO, and will continue to do so to make sure that they support us in that respect.
And again, I think we were having a conversation last week and you said that the EPO are incredibly supportive in terms of the UK carrying on as it always has.
Absolutely, yes. And, we spoke to Mr. Campinos only a few weeks ago, and the EPO are going to put another statement on their website, I think nearer the time that we do Brexit, to make it quite clear to all and sundry that we still have the right to act before and go to hearings at the EPO.
So I think the big takeout for me on this, for not only our members, but also the people who rely on the services of our members, their clients, is, this is something we need to think about. We can't be absolutely clear on it yet because there are some unknowns in here, but CIPA's doing work on this in all the ways that it can, if that's taking informal or formal advice, if it's working through the various agencies, and when we're able to update people, we will.
Absolutely.
Speaking about updates, and I'm going to continue directing this one at you, Julia, if that's okay. It's the UPC question. So the question from Duncan is, will Germany ratify even if the constitutional challenge is resolved, or will it wait until after Brexit?
Well, I can't speak for Germany, but we have heard that the German case is ongoing. There are one hears various rumours every now and then that they're getting close to resolving the matter, that they're holding off until Brexit is done. I think there was some concern that if the decision came out very close to the Brexit date, there'd be a bit of a scramble to get the sunrise period sorted out and to do all the things, before the court opens. But it's hard to know how true any of that is. But I can understand perhaps why people might want to wait. But of course, the longer things are going on, perhaps, if they've essentially made their decision, I don't know how long they would want to sit on it, knowing that we have another extension. And so I'm afraid it is just a case of watch this space, and we are watching it very, very closely.
We were, of course, told to expect some kind of update from the German Constitutional Court after Christmas. That was last Christmas. We're a couple of months away from another one. So who knows, maybe early in the new year, perhaps just after January the 31st.
Perhaps we will hear. But, and the understanding is that if we leave with the withdrawal agreement in place, then that withdrawal agreement allows for UK participation in the UPC during the implementation period. So that would be up to December 2020.
Yeah.
And then obviously after that, we need to make sure that is our continued participation is part of the negotiations for our future relationship with Europe. And I know that that's something the UK IPO are working on.
And we've been pressing that in every opportunity.
Absolutely. And not just us. I mean, I think it's worth saying here that CIPA's been working very closely with CITMA and with other IP organisations to ensure that we give the strongest possible message about the importance of continuity and stability and certainty in IP post-Brexit to the government. And I think they are hearing that message loud and clear.
Yeah, it's been, and actually it's, I speak often with my sort of colleague chief execs in other professional bodies, many of whom are doing events like this week because they're all engaged in the Brexit Readiness Fund, and we've all said that whilst this has been quite a challenging time for us professionally and also personally in terms of what you think yourself about leaving the EU, it's actually been quite an interesting period to be alive, hasn't it, in terms of the work that we do, so we should at least take that from it, I think. Alicia, if you're still with us, we've got a trademark question that's come in from AJT, which could be a firm or could be an individual, who knows? And the question is, if UK trademark attorneys cannot represent clients at the EU IPO, will non-UK attorneys, people from outside the UK, be prevented from representing clients in the UK?
No.
There was a lobbying response there, wasn't there? It should be heard loud and clear by government. Yeah.
Yes. So they are not changing, the UK government at this time are not changing the rules on representation and address for service within the UK. So provided that you have an EEA address for service, it's business as usual for them and they can carry on. And we as CIPA, CITMA, FIGP, many other organisations have been lobbying the government, very much so, and we've had meetings with the MOJ where they got severely told off for this unfairness and the fact that they've just given this away willy-nilly without any recourse. The government, despite them taking it down from their website, have reassured us that this is under review. And while the withdrawal agreement had a 3-year time period in for looking at changes to this, if we had a no deal, there is no such delay period in there. And so there's no reason why once they get their act together, once they've got the IT sorted after Brexit, they couldn't relook at this. Wow. We have pointed out to them that's nice, but everybody's lost their jobs in the meantime. But we'll continue to keep pushing, and at every opportunity I do bring it up.
And I think in terms of government's order of thinking on these things, this is some way down the track, but hopefully it comes into sharp relief once we've fallen over the cliff and we're kind of travelling through free fall.
Yeah. We have made it very clear to them every opportunity. You do realise what you've done here, and they might see things, they might not. Well, we shall see. But at the moment, they can continue, no issue. And we have pointed out it's very unfair.
Just to prove that these regional hubs exist, we've got a question from Manchester. And that question, is there any information on how the UK IPO will deal with errors generated when mirroring existing EU rights into the UK's IPO's records?
They have indicated, it depends on what errors there are. So errors in translations, they've specifically said if the original application wasn't in English and the second language wasn't in English, and you notice that there's a nonsense in the translation that's come across, they can be corrected. The UK IPO are very, I mean, all the information is kind of there already, because already now you can access the EU IPO mark, the EU marks on the UK IPO's register, so you can see everything there. So hopefully there shouldn't be too many errors, but if you do spot any, they're very open to things being corrected as long as you let them know.
So again, be vigilant. Be vigilant. Feedback.
If you spot anything, let people know straight away. And they have some email addresses. They're in our practice notes, also in the notes on the UK IPO's website, with some generic email addresses for reporting on when you've renewed a trademark late or you've restored a trademark or equally a design, to let them know to then update their records. And I'm sure you can put something through this in the same way. They have specifically said about correcting errors in translations, but not specifically anything else, but see no reason why we couldn't.
Thanks, Alicia. A tester for you now, Matt, but also for me in terms of my German pronunciation. Will there be any change to the admission requirements for non-German patent attorneys to the Patentanwaltskammer?
Again.
You got to love these questions.
Yeah. Well, that's a question of German national law for admission.
Yeah.
So you're not going to be able to, obviously, you're not going to be able to use any use your EU nationality. But in order to get into Patentanwaltskammer, then you do need you've got to pass the exams. Did it so?
But my understanding is there's no nationality restriction, so so it's a question of meeting the academic and
meeting the requirements.
Yeah, and that's not going to change. So.
Right.
Yeah, I think.
We think.
What do I know?
But we have seen some moves from the Kammer to enhance
that's true.
The requirements for national representation.
We've certainly had more correspondence from our members based in Munich in terms of things that the Kammer's asking from them to maintain their
and
admission.
certainly experience suggests that it can be the practical requirements that are difficult to meet,
Yeah.
rather than necessarily the academic requirements. So again, it requires ongoing vigilance.
So I'm going to just move us back to the room in case there's a question anywhere. Anyone in the room? There's a gentleman in the middle there. Hello, sir.
Hello. So most of the discussion up till now has been sort of looking at problems and how we might mitigate the problems and prepare for difficulties. Are there any opportunities offered by UK leaving the EU?
I think this is one for each of you. Who wants to start?
Well, we've clearly got a 9-month period, haven't we, in which we get to re-register a bunch of rights, and then we've got a doubling potentially of the number of rights that our clients have. So in theory, there should be more things to do depending on the appetite of the client base for protection in the UK. And the UK remains, what are we, number 7 in terms of world economies?
Yeah.
So still an important market. And so, yeah, I think that's definitely one of the opportunities is there is more to be done because not everything is now covered by EU rights.
So celebrate the distinction of being outside the EU but still within the European IP system in some way, shape or form and build on that. Julia?
Well, as we said earlier, all current EU legislation will, as of day one, be retained as UK law in the same form. But after we Brexit, then the UK is at liberty to change those laws if we so wish. Whether that presents opportunities in the IP space, I'm not entirely sure. But for example, we've recently the SPC regulation for people who work with pharmaceuticals and other products that are subject to supplementary protection certificates. Those obviously those regulations will be adopted into UK law, including the recent amendment that was made, it's been in force now since July, called the SPC waiver, which is a provision that is going to enable generics to manufacture for certain limited purposes within the SPC period. And that was hotly debated. Now, after Brexit, we will have our own UK SPC waiver. But whether we want to keep that the same as the EU version is something that I suspect will be looked at. Of course, our view has always been that alignment is the best position. And certainly in terms of SPCs, I think it's going to depend on how close alignment we still have between the, because SPCs are based not only on patents but also on pharmaceutical marketing authorisations, it will to a certain extent depend on how close the alignment is between the UK Medicines Agency and the EU Medicines Agency. If we're going to keep the authorisations for medicines in step as far as possible, then we probably want to keep the SPC regulation in step as far as possible. But there may be things that people would want to change.
Scope for a little bit of commercial advantage, maybe.
Possibly, yes. Well, we'll have to see. But so I think that's probably the next phase now, is to look at whether there are things that would be better to change once these regulations become UK law.
Thanks, Julia. Alicia?
I thought I'd highlight two slight alternatives
Okay.
here. I'm bringing these into the mix because people might know about them and they've got slightly different rules. So, geographical indications, GIs.
Yep.
The UK is going to be setting up schemes that mirror the EU schemes. However, contrary to trademarks and designs, the only geographical indications that are being brought over automatically are the 88 UK-based geographical indications. Nobody else is. Everybody else has to reapply. So if anybody on the EU registers wants rights in the UK to protect Champagne, Bordeaux, etc., and they're going to have to reapply onto the UK register within 9 months. So we've got this, again, a huge amount of geographical indications work that is up for grabs. And then also we have some plant variety work possibly up for grabs. So with plant variety rights, all granted rights will be coming over onto the UK register that have been granted 2 months before we leave. Any that are pending at the time or granted less than 2 months before we leave because they have a 2 months appeal process, again, you need to reapply onto the UK register if you want rights. This time it's 6 months. You've got 6 months. So these are some slight nuances, and there is confirmation from the UK that all existing EU plant variety rights will remain in existence for the remainder EU 27 countries. But I just a couple of other areas that you might want to look into as business opportunities.
Yeah. Well, the GI one is particularly interesting, isn't it? Because I don't think I taught myself enough about the transportation of EU GI rights into the UK, and that's something people have to think about carefully. So,
says the cheese lover.
so a question from our Glasgow hub. Are there differences in representation rights for representatives based in Northern Ireland? And I'm guessing this is a question that might have something to do with a notional border between mainland Britain and, yeah.
So I had a look at the latest version of the withdrawal agreement.
Well done.
Thank you very much. That was a fun day.
And you still turned up today. That's,
that's
magnificent.
right. And the differences in for Northern Ireland all appear to relate to goods rather than services. They don't appear to relate to services at all. So I can't see why there would be a difference in representation. I haven't seen anything specific, but I can't see why there would be a difference at all as far as representation is concerned.
So our expectation is no change, but we would need to kind of keep a watching eye on that just in case anything snuck up.
So our expectation is that Northern Ireland would be in the same position as the rest of the UK in that respect.
It's another one coming your way, Matt. That's a question from Daniel Adams, who says, what effect is there on UK EPAs employed in EU firms? For example, a UK EPA employed in a French industrial department. And also vice versa, on a French EPA employed in a UK industrial department. So it possibly touches back on that residency issue.
So yeah, it relates simply to the way that EU nationals will be treated post Brexit. It's straightforward. There's actually, that's an area where there is a reasonable amount of information regarding UK nationals in. Regarding EU nationals in the UK and their ongoing rights and registration, and then it's a question of national law. I don't know about the French position in there. We looked at the German position.
We did look at the German position, we did,
but I don't know about the French position, and it would be one to take local advice on.
Yeah, of course.
But those kinds of things are relatively straightforward because they don't have the twist of anything to do with our particular profession.
It's going to be a little bit unfair on the panel again now and perhaps sneak into that sort of like nasty area of political considerations. 2 questions. I'll take them one at a time actually so as to not confuse the panel. The first is, why is the government allowing the UK to leave the EU IPO and stay in the EPO? I don't know if that's a question that's arguing for us to leave the EPO or stay in the EU IPO. Does this not result in a really bad deal for UK businesses?
I don't think it's a question of allowing, it's a question of the operation of law.
Yeah.
In that, as we've discussed, and Alicia's made very clear, that the EU IPO is a European Union agency, body, and therefore once we exit, we can't stay in. Unless, CIPA had always been pressing for a very close alignment such that we may be able to participate after Brexit in various EU agencies, including the EU IPO, but unfortunately, to date, nothing's really come of that.
And I think it's fair to say we had some success, didn't we, in our conversations with parliamentarians, particularly in the House of Lords,
Yeah.
who saw good reason for the UK to still maintain a relationship with the EU IPO. It does appear to be off the agenda at the moment, but that doesn't mean to say that Brexit is still a long way off being done, and actually leaving the EU is not the end of it, is it? So there may not be much hope for the future, but we'll continue with our work in terms of trying to lobby for the very best outcome for business.
Alicia, I believe I'm right in saying that if we have the implementation period, then everything continues as currently is until the end of that implementation period, and then that's going to depend what can be negotiated in terms of the future political relationship. And we would continue to press for close alignment.
I think on this point, it's something that we've lobbied for in terms of demonstrating the value of our profession. We talk about it being a £1 billion business and of value to the UK economy, the patent and trademark profession. And I think in the interest of our members, we have tried hard to get the message out that that's important. Because obviously that's a continued business. But I think the other message that we've put forward is that it's really important for the UK, because having a strong IP profession in the country helps protect UK innovation better. So you see those countries that perhaps have a profession that has waned, and that makes it difficult for them to get those strong IP protected for their businesses. So I think it is good for UK businesses, for UK patent attorneys to be strongly engaged with the EPO, because you get a better core of patent attorneys and better protection for UK business.
And of course we do need to negotiate a trade agreement with the EU off the back of leaving, and who's to say that the EU IPO question couldn't return to that to the agenda then?
Well, we have good relations with the EU IPO, and they like us and they respect our input. Even now we're still going to all of the meetings, as are CIPMA as well, and they haven't sort of said it's off the table about closer cooperation in the future. I mean, they have close cooperation with many third countries, so there's no reason why we couldn't cooperate closely in one of those respects. But the problem is, at the moment, no one's talking future trade until we've got the withdrawal out of the way.
Gerald asked a supplementary. It doesn't really relate to the first question, but it's still a political thing, I think, and that's can the UK move forwards with trade negotiations if it is part of a European patent system?
Well, I think the answer to that is yes, because the European patent system is separate from the EU, and so the EPO patent system also currently does include a number of countries that are not EU members. So there is already the model for that. We won't be the only non-EU member of the EPO, EPC, so it should have no bearing at all on trade agreements.
And I think it's fair to say that there are obviously lots of discussions within government at the moment about future trade negotiations, and I think we can say that CIPA is well connected with those discussions, and that we will do our absolute best to make sure that the UK IP profession, but also those who benefit from that profession, the UK IP rights holders, aren't disadvantaged by those negotiations.
Absolutely, yeah, that's quite right.
I think it's also worth recognising that the EPC as a patent system is recognised internationally. So so there are countries adopting EPC systems way beyond Europe, and so actually it can be seen as a strength of the UK in trade negotiations as being part of a strong and well recognised patent system.
Thanks, Matt. An anonymous question. You always worry about these, whether someone forgot to put their name in a box or whether they've got reasons for wanting to be anonymous. But what differences are there between the withdrawal agreement that was approved by Cabinet and the no-deal scenario for IP rights?
Well, Matt said he's
read it. So no pressure, Matt.
I don't think there is any. There's none.
No, I don't think there is any.
Don't think.
I can't see anything obvious.
No, I don't
No.
know. So I don't.
The same thing happens at the end. It just takes longer to get.
The end is sooner
Yes,
for
yes,
trademarks
yes,
and designs. But,
absolutely.
that's about it, really, isn't it?
Yeah.
No, there've been, certainly in all the discussions that we've had with the UK IPO, they had indicated that there would be no changes to the IP aspects because those were well negotiated. There were really not much argument about them, if any. I think they were. Everybody was very happy with what had been agreed on both sides in the UK and the EU. And
isn't that the comparison between withdrawal with a deal and withdrawal with
Yes,
no deal?
it's exactly
Yes,
that, yeah.
Exactly.
Yeah.
Okay.
Another anonymous one. Hi. Hello. I run a small creative business in Sweden. Will I need to be patenting my inventions in both the UK and the EU when the UK leaves?
Yes.
I think
Definitely.
Absolutely.
We're always happy if people want to patent in the UK.
I think we may have
but-
rehearsed this one to death, but shall we say it again?
Well, I think as the previous discussions have made clear, we can still carry on using the EPC, filing applications at the EPO, and UK attorney can continue to draft and file an application, file it at the EPO. It will cover as many of those EPC countries as you want it to, including Sweden, and the UK. So, and then, as now, when the European patent application is granted, it then becomes a bundle of national patents, and it's up to the applicant to choose which countries they wish to pay for.
Yeah.
And I think it's worth noting that many applicants in Sweden and other Scandinavian countries choose UK attorneys because of the experience and excellence, so continue to do that.
Yeah.
I'm conscious we've got about 10 minutes left of our time today, so I'm just going to swing back to the room here at CIPA to see whether we've got any more questions. There's one down the front, please. Hi.
Peter Jenkins, on the positive side, there seems to be a positive side to me. A number of UK firms, of which mine is one, has actually taken Brexit by the horns over the past few years and opened offices in Europe or partnered up with somebody else in Europe. Isn't that an opportunity for us? Because we could provide our firms with a broader service and our clients with a broader service. If it's going to happen, let's be positive about it and make a, as Matt says, this opportunity disguised as a problem.
I think that's right. I mean, lots of commentators suggest that there is going to be consolidation of firms either at a national level or at a European level. In other words, that firms are going to generally tend to get larger.
Yeah.
And so if those are getting larger on a, whether you call it pan-European or Anglo-European level, then I think that does make sense because you're covering more opportunities. So yes, I mean, that's an excellent example of turning what seems to be a threat into an opportunity.
Now, I'm going to ask the next question, Julia. I might get it horribly wrong because SPCs are not something I've been anywhere near, and I suspect this is an SPC question. But so it's from Keith H, who says, will the UK courts find rulings of the CJEU on the provisions of the biotech and IP enforcement directives, I think that says they relate to SPCs, persuasive, even if those rulings are no longer binding when we leave?
Right. I think they're actually a bit separate from
Oh, are they?
SPCs, but so will the court find the rulings persuasive? I think, obviously, as we know, once we've left the EU, we will no longer be bound by the CJEU, although existing decisions of the CJEU will still continue to be part of our case law and will act as precedent.
Yeah.
So if we're talking about decisions that the CJEU makes after we leave, the court will not be bound to follow them, but they can take them into account. And indeed, the courts currently not only take CJEU decisions into account, which they have to, but also decisions of European national courts, German, Dutch, French. They do look at those decisions when debating questions, and I think particularly in the IP field where we have a lot of harmonisation in Europe, and we are supposed to have harmonised patent law, and so judges do talk about how to make sure their decisions are following, for example, EPO case law as well is something that's taken into account. So yes, I think they still will look at CJEU decisions. How persuasive they'll find them, I think, will be obviously on a case-by-case basis. But we know, for example, that Switzerland, I know that the Swiss courts have followed a number of CJEU decisions in relation to SPCs. Maybe that's where you're thinking of the SPCs. And in fact, I think there was one instance, if I'm right, I'm going back a bit now, where the lower court didn't follow the CJEU decision, but the Supreme Court in Switzerland then did. So, yeah, I think we're going to probably be in a very similar situation.
And does this distinction, and this isn't now specifically about this question, but this is more generally about litigation, and for any of the panel really, does this distinction of the UK being outside of the EU, distance from CJEU, make the UK a more attractive place to conduct litigation?
I think the UK is an attractive place to conduct litigation anyway. So I don't, again, I think it's going to be a case-by-case basis. If somebody doesn't like a decision of the CJEU, then they might think they'll have a pop at seeing if they can get a different decision in the UK. But
maybe what we want
in many cases, people do actually like the decisions of the CJEU.
Yeah.
You know, it's been held up as something we don't want to follow, but it's been useful in some areas. And perhaps less useful in other areas. I don't know if the other panellists have got views on that.
Yeah. Trademarks, we get some interesting decisions sometimes.
And it's a hotbed for trademarks. So.
It is, and I think it would be better if we had more trademark judges, but you can't pick and choose your panel. I think other areas it can be.
I think on Lee's point, I think there is a potential opportunity there to use the strength of the UK patents courts to demonstrate that there are good and well thought through decisions based on expert evidence that are then at least internationally recognised as being well reasoned, and I think as a flagship jurisdiction for litigation, then the UK may very well have a strong future.
And recognising we've got a global audience today, the message very much is the UK is open for business when it comes to litigation.
Absolutely.
Indeed.
Very much.
So, folk, this is our final question before we then move to close this off. So, it's coming your way, Alicia. Are there any moves to amend the rules on the Madrid Protocol so that EU designations will give rise to UK designations rather than UK registrations?
Short answer, no. Not under the current no-deal situation. So if there's a no-deal Brexit, the UK bits that are divided out from the European designations will become UK national registrations. You can put them back in again as a there's a way you can surrender the trademark. The WIPO have got some special rules, so you surrender your UK trademark and it goes back in again as a UK designation. So there is a way of getting them in if you really want them in, but not automatically. If we end up getting a deal, UK and WIPO will begin discussing again, because they were partway through it. It's just they then had a switch round of staff and things fell apart a bit. So they will, and we will press again for them. Every time we meet them again, we say, you know, can you put this back on? Last time there was a delay, we said, can you put this back on the card? And they said, no, because it takes too long to work it out, and especially if you've got a moving target of, you know, with the extension, but it might not be the full extension. I think it's difficult for them to organise. But if we end up in the withdrawal agreement situation, it will be something that they will revisit, I think, but not in the short-term sort of no-deal scenario.
So this is something for the future in terms of negotiations.
Yes.
Well, to your relief, your work is done. So you can't leave, Matt. So Alicia, Julia, Matt, thank you very much for giving up your time this afternoon. It's never easy to do something like this because you don't know what the questions are going to be, and you set yourselves up really to answer those questions, and you've done it magnificently. I also have to thank everyone who's turned up here at CIPA to provide a physical audience for us to address, and everyone globally who's participated in this. I've been told through the wonders of people's talking to you in your head when you're doing these things that we've been absolutely inundated with questions online, and that we don't have the chance to respond to all of those, for which we apologise, but we've also captured all of this. We're going to be putting out quite a lot of information about Brexit, both deal and no deal. When we complete the activities that we've got planned within the Brexit Readiness Fund, so there will be a special edition of the CIPA Journal coming out, there'll be some more online resources, and we will try and pick up as many of those unanswered questions as we can there. So we reach towards a conclusion. We've just got two things to ask of both the audience here and the audience online, and that's to give us some immediate feedback if you can. This is really exciting, immediate feedback. So I want you, using the wonders of Slido, to give me one word which sums up what you will take away from today's broadcast, and then we will see your thoughts grow on the screen as you offer us that word. Have I sold it? Is it exciting enough? So people here, people in offices, in the regional hubs, at home, if you can just give me one word that sums up what you've got out of the event this afternoon. Oh, informatives come through large, so that I think that pleases us. That pleases us. Uncertain, yeah, I think.
Ditch.
Ditch. Oh, ditch. Presumably that's somewhere that you might end up rather than that we should. That we, yeah.
I see the word shirt has appeared.
Shirt.
I think that might refer to you. Helpful.
This isn't lost to us. This will continue to grow. Which one have you just seen?
There's one on the right-hand side that I saw. It's not.
Disappeared now.
It's disappeared.
Somebody over
Shirts trending.
Ditch has gone up as well.
So Ramona's on there as well. I think I've been quite careful not to be politically obvious at all. So I think we'll let that carry on to grow. But the final thing that I'm going to ask all of you, wherever you may be participating in this, and then we'll just say farewell, is if you've not had the chance to ask a question that you'd like to have answered, please type it into the next box that you've got on your Slido screen. We will do our best to answer those questions through other media in the future. And thank you all for your time this afternoon. We've thoroughly enjoyed it. I hope you've enjoyed it and found it informative. Thank you all and goodbye.